Welcome to this webinar being presented for the Disability Justice Project, Navigating the Criminal Justice System. This webinar provides an overview of the content of the two-day course of the same name, which was offered as part of the Disability Justice Project training program. For further information about the face-to-face training package, please contact the Disability Justice Project or the Intellectual Disability Rights Service directly. All information given in this presentation is legal information only and does not constitute legal advice. All people with disability and their supporters and organisations must seek advice about their own individual circumstances if they have a legal matter. My name is Ben Garcia Lee, and I work for the Intellectual Disability Rights Service, or IDRS, and I am presenting this webinar as part of the Disability Justice Project. We are going to be discussing some of the experiences of people with cognitive disability who have come in contact with the criminal justice system, and we are going to talk a lot about disability. The reason for this is that it is in a person's best interest for their disability to be identified in the legal system so that they can receive the support that they are entitled to, and also so that they can have the support to achieve the best possible outcomes for themselves. People with cognitive disability and Aboriginal people are overrepresented at all stages of the criminal justice system. In this webinar, we are only able to provide legal information about the system and some of the support needs of people with cognitive disability. This webinar does not constitute applied practical training in this area, and we advise that people that are interested in supporting people with cognitive disability at police stations or at courts seek and complete more detailed face-to-face training in this area. The focus of this webinar is on defendants with cognitive disability over 18 years of age. Separate courses on supporting young people and victims in the criminal justice system are also available as part of the Disability Justice Project suite of training. You can see the DJP website for more details. Today, I will cover some of the important elements of the criminal justice system and its processes as they relate to supporting a person with cognitive disability to navigate its complexities. The particular areas of focus for today's webinar are an overview of some of the issues faced by people with cognitive disability in the criminal justice system, a brief overview of police powers and the rights of the public, police arrest processes and the rights of a vulnerable person in custody, court processes and how people can get support through court, and a brief introduction to Section 32 of the Mental Health Forensic Provisions Act 1990. The key message throughout this webinar is that cognitive disability is often not identified in the criminal justice system, and therefore people do not receive the support that they are entitled to, and therefore do not have access to exercise their full legal capacity. And the research suggests that people with cognitive disability have worse outcomes in the criminal justice system than the general population without disability. I'm first going to outline some of the issues and challenges typically faced by people with cognitive disability in the criminal justice system. These are some of the common issues that IDRS has encountered through our practice experience when supporting people at police stations, at courts, and who have been given prison sentences. The overarching issue is that there is an under-recognition of cognitive disability. And if cognitive disability is not identified, and if people with cognitive disability do not self-identify, then additional supports that are available to a vulnerable person in the criminal justice system cannot be activated. Some of the issues at a police station that a person with cognitive disability may face is that they may be arrested, questioned and detained for relatively minor offences. Without identification, suitable support may not be provided. Admissions may be made. People might confess to a crime that they have not committed. Rights may not be explained or understood, or people with cognitive disability may not know that they have rights when they are under arrest or going through the court process. And people with a cognitive disability may be refused bail. At court, there are a number of issues that can be very confronting for a person with a cognitive disability. The process itself can be very difficult to understand and can be quite intimidating and scary. Without appropriate support, people with cognitive disability might not show up or might leave early, not understanding the court processes or what their obligations are while there. Legal representation can be problematic for people with cognitive disability, and they can also be convicted due to a confession rather than plea bargain. They can often be refused bail. Frequently court orders are not understood, which leads to a much higher risk of breaching bail, rearrest and additional charges. People with cognitive disability can receive sentences, so custodial sentences, due to a lack of alternative placements available for them. And diversionary options are not always considered or used appropriately for people with cognitive disability. If somebody with a cognitive disability is given a custodial sentence, there are a number of issues that they will face in prison. Vulnerability being foremost amongst them. It is often reported, and IDRS has supported many clients who have spent large amounts of time in solitary confinement for their own protection while in the prison system. The consequence of this is that people are experiencing punishments very disproportionate to the original offence which led to the jail sentence being handed down. We've also found that very often people will lose services and support that they've often fought long and hard to have established in the community during a time of incarceration. There are very often issues with loss of housing, and there is always the stigma of having been in prison that makes reintegration into the community all the more difficult for people with a cognitive disability. There are, of course, many other challenges, but these are just some of the key issues that IDRS have identified in supporting people with cognitive disability at these different stages of the criminal justice system. There is a significant body of research which shows that people with cognitive disability are significantly overrepresented at all levels of the criminal justice system. Having said that, having a cognitive disability does not predispose an individual to commit offences, but it does, in association with a range of other cofactors, including but not limited to socioeconomic disadvantage, limited support networks, substance misuse, homelessness, unemployment, childhood trauma, and contact with the care and protection system, which all put a person with cognitive disability at a greater risk of criminal justice contact. Having a cognitive disability can make an individual more vulnerable to criminal justice system contact. Some of the common effects of having a cognitive disability is an individual may have difficulty learning or lack the opportunity or the exposure to learning opportunities or learning environments that suit their particular learning needs. Many people with cognitive disability will require specialist teaching to learn what others learn quite easily. The people you support may not have had the opportunity to learn that the behaviour leading to their charge is against the law. and this then provides an explanation of one of the links to the criminal justice system that people with cognitive disability are vulnerable to. How could this be prevented? We need always in our work to have a focus on early intervention strategies. And if we are working with people with cognitive disability, it's critical that people are taught about appropriate behaviours where possible, or referred to appropriate services or groups where this education can be made available to them. Another important point is that people with cognitive disability and their support people are given the opportunity to understand police powers and to develop an understanding of these so that people can avoid, where possible, coming in contact with the police in the first instance, but if they do, to understand their rights and what additional supports they are entitled to. Police powers, knowing your rights and responsibilities. We've found that this is an area where often people with cognitive disability and their supporters have limited understanding of what police can and can't do in many given situations. This slide will detail just a few illustrative examples of particular things that police are able to do, and we will also then briefly talk about some things that police are not allowed to do. Unless the police arrest you, you do not have to go with them. Police can search you, your bag and your car if they reasonably suspect that you have something stolen or unlawfully obtained, or something used or about to be used in a crime. If the police stop to ask you questions on the street, then you don't have to answer any questions other than your name, address and age. It is an offence to disobey a police direction to stop you obstructing people or traffic or causing fear to other people. If this direction is disobeyed, it can lead to arrest. A police officer can detain you if you are an intoxicated person in a public place. The first point is critical when supporting people with a cognitive disability, as very often an invitation to talk to the police can be interpreted as an order that people are obliged to comply with. But it is very important that workers are aware and that it is communicated to clients that you cannot be arrested for questioning. Police can ask you to accompany them to the police station for questioning, but you are not required to go unless you have been arrested for an offence. You should get legal advice before speaking to the police. And I'd like to reiterate that it's incredibly important, if the police want to speak to an individual with cognitive disability, that they seek legal advice before speaking to the police beyond giving them their name, address and age. You do not have to be under arrest before you request to have legal advice. These are just some of the common assumptions regarding police powers. But it is just used as a demonstration to suggest that it is really important that workers seek additional training to know what access rights police have to their clients and what they are obliged to do and what evidence they are obliged to share if approached by police during an investigation. If you'd like further information in this regard, please contact Intellectual Disability Rights Service and we'll be happy to support you with further information. It's also very important that clients are made aware that if at any time a person with cognitive disability believes that they have been treated unfairly by police, they should contact either the Intellectual Disability Rights Service or Law Access for free legal advice as soon as possible after the incident has occurred. In the following slides, I'll outline what happens when someone with a cognitive disability is arrested in New South Wales. If an individual is arrested for an alleged offence, they will be conveyed to the station by the arresting officers. On arrival at the station, they will be introduced to the custody manager. The custody manager is responsible for the welfare of alleged offenders while they are in the police custody area. It is the custody manager's responsibility on arrival to perform a physical observation and ask medical questions and ascertain whether any kind of medical support is required for the person who has been arrested. Ideally, it is at this point that a custody manager would identify that a person has a cognitive disability, and that processes would be enacted to seek a support person for that individual. This is a major issue for people with cognitive disability, as frequently this does not occur. And for those of you who work in the sector, as you'll be aware, many of our clients do not self-identify as having a cognitive disability, and there has been research to suggest that police still overwhelmingly rely on physical characteristics to try and identify disability. So therefore it is obvious that this is an inadequate screening tool for somebody who has a cognitive disability. The point that is important to make here is that if you know that a person with a cognitive disability has been arrested or is going to be arrested, that you notify the police that that person has a disability, and also that you notify a specialist service like the Intellectual Disability Rights Service to let them know that a person with cognitive disability has been arrested, so that they can then contact the station and offer appropriate support to that individual. Assuming that disability is identified, then certain processes are activated under the Law Enforcement Powers and Responsibilities Act 2002, or LEPRA as we will refer to it. The police are required to make every effort to provide a support person to vulnerable people during investigative procedures. It is important to say that this does not just mean for police interviews. This means for cautioning, charging, reading bail, and explaining bail and other investigative aspects. The majority of people that IDRS supports at court have never received such support at the police station because their disability has not been identified. There are 5 categories of vulnerable people under LEPRA. People who are of Aboriginal and Torres Strait Islander descent, people of non-English speaking background, children, so anybody under the age of 18 years of age, people who have impaired physical functioning, so people who have some level of physical impairment, and people who have impaired intellectual functioning. It is under this 5th area that people with a cognitive disability are considered vulnerable persons under the LEPRA legislation and are therefore entitled to a support person to support them through the custody processes. I would just like to reiterate, and I hope that this makes it more evident as well, how critical it is that somebody's disability is identified either by themselves or by their support people, so that they can have the support that they are entitled to. It is also an important message to give clients who are at risk of contact with the criminal justice system that it's critical that they tell the police that they do have a disability if they are arrested. A project of the Intellectual Disability Rights Service, the Criminal Justice Support Network, provides trained support people at police stations around New South Wales. Where possible, in the regions where we have trained people, we can provide in-person support for victims, witnesses or defendants with an intellectual disability. Where it is not possible to provide a support person in person, indirect support is available from trained staff over the phone who can provide direct support to clients but can also provide support and information to family members, friends or disability workers who are supporting a person with cognitive disability in custody. Also, this service gives people with cognitive disability in police custody access to free legal advice 7 days a week, 365 days a year between 9 a.m. and 10 p.m. And you can see the number for this service if you require a support person to come and if you require legal advice on the bottom of this slide. I'll outline briefly what the role of a criminal justice support person is when they go to a police station to support someone with a cognitive disability. It should be noted that any community volunteer undertaking this role has had all of the appropriate checks taken and has completed a minimum of 2 days of training which would enable them to provide support at courts. If they are providing support at a police station, they will have completed another 2 days of training, so in total 4 days of training. 7 key areas of the support role: providing emotional support to people with a cognitive disability, assisting people to access, understand and remember legal advice and exercise their legal rights, alerting police when the person may not be understanding questions, assisting people with cognitive disability to understand their rights at all stages of the process, offering suggestions to the police to maximise clear communication, and to raise any special needs the person may have if necessary, e.g. medication that they need which they do not have with them at the station, healthcare concerns, etc. It's also a very important part of the role that the support person is there to assist in explaining bail conditions to the person with cognitive disability. An important message to be taken away when thinking about the role of the support person is that a support person is not there to ask police questions for them. A support person is not there to support the investigative procedure. They are there to support a person with cognitive disability to understand their rights and to exercise their rights. So identifying communication problems does not mean asking police questions for them. Some of the key rights that a person has while in custody are: 1, the right to say or do nothing. And this means that beyond giving name, address and date of birth, a person under arrest in police custody is not obliged to say or do anything further. Second, they have a right to contact a third person, family or friend to alert them to their whereabouts. 3, they have a right to legal advice. 4, they have a right to a support person if they're vulnerable. And as we've discussed under LEPRA, there are 5 areas, five groups in the community which are considered vulnerable under the LEPRA legislation, and that includes people with any level of cognitive disability. They also have, number 5, a right to privacy with a lawyer or support person, and 6, a right to an interpreter. It's important for people with cognitive disability to know that just because they choose to exercise their right to say or do nothing, that this does not increase their chances of being charged with an offence, and it does not reduce their chances of being given bail. The next slide details who a support person can be at a police station in New South Wales under LEPRA. A person with cognitive disability can choose who they would like their support person to be. This may be a friend, family member or guardian, or it may be a person with expertise in relation to the disability. One example of this would be an IDRS trained criminal justice support network support person. With additional training, it may be workers from support organisations, but it is important to remember that it is the person with cognitive disability who is under arrest. It is their choice who they would like to have as a support person. The next slide, the next two slides in fact, will detail some of the times when it is not appropriate for a particular individual to be a support person. If, and this is very important for support workers, if there is a conflict of interest for a support worker in providing support at a police station for a person with cognitive disability, it is important that this is identified and that services are clear on what their internal policies and procedures are in relation to conflict in this area. If you have any questions about conflict of interest, I would encourage you to contact the Intellectual Disability Rights Service to discuss your individual circumstances. Some instances when it is not appropriate to be a support person: if you have been a witness to what the arrest is about, it is not appropriate for you to be a support person. If you're negatively affected by what the arrest is about, everybody has different triggers for things that they find unacceptable or challenging, and it is not in a client's best interest for somebody to be their support person if they're personally negatively affected by what the arrest is about. Also, if you feel ambivalent about what the person has done or is alleged to have done, you are not best positioned to provide support to that person to exercise their legal rights to the best of their legal capacity. Probably most importantly, if the person under arrest is opposed to you taking that role. It is very important at this stressful point in an individual's life that they are able to exercise their right to choose the most appropriate support person for them. Another instance when it's not appropriate for somebody to be a support person, and this relates particularly to people working in services supporting the individual, is if it's a serious offence. IDRS takes the position that it would be preferable to have an independent support person who's been specifically trained in custody processes and in the support role to step in if there is a serious offence that has been committed. So then that leads to the roles of the custody manager themselves, and these points have been adapted from the Police Code of Practice for Crime. A custody manager must attempt to contact someone responsible for the person's welfare to advise them of the arrest. All of these 5 key points are assuming that a person has been identified as vulnerable, and in the context of this webinar, that means that a person has been identified as having some kind of cognitive disability. The second point, if they suspect that someone is a vulnerable person, they are to take immediate steps to contact a support person. This is critical. Police do not require documentation to prove, or evidence to prove, that an individual has a disability. If they suspect that a person has a disability, or if a person self-identifies as having a disability, then police are obliged to take immediate steps to contact a support person. The custody manager must also establish whether the person is suitable to be interviewed. They must also ensure that a support person be present during cautioning, interview if it is to occur, access to the custody record, and charging. A person with cognitive disability may well be deemed an incapable person in relation to consenting to forensic procedures, and if this is the case, then police are obliged to get a magistrate's order before proceeding with forensic procedures. It is clear from looking at this list why it is critical that an individual with cognitive disability in custody receives legal advice. I will give you a brief scenario to demonstrate the impact of when a support person is contacted too late in the process because disability has not been identified or support has not been activated as appropriate. Bob was arrested and taken to the police station, but no support person was obtained for him, as the custody manager didn't fully understand what the support person's role was or what the Criminal Justice Support Network's role was. He called the Intellectual Disability Rights Service after the client had been processed, but before the bail decision had been made. The IDRS on-call staff member explained to the custody manager that a support person was required throughout the police station process. Bob had already refused to participate in an interview. If he had have answered questions, his lawyer at court later on would have been able to argue that the interview should have been inadmissible on the grounds that he did not have a support person when he was entitled to one. When an individual is arrested and taken into police custody, there are three possible outcomes. The first is that there will be no charge and that the person will be released because the investigation has either been completed or possibly because the police intend to undertake further investigations. The second option is that the individual will be charged and that they will be granted bail. It is really important in this situation that a support person is present so that a person with cognitive disability understands the seriousness and importance of their bail conditions and how critical it is that they meet their bail conditions. One of those conditions will always be that a person is obliged to attend court, a particular court on a particular date, and they will be given a court attendance notice to this effect, or a CAN. There may be, depending on the alleged offence or the circumstances, there may be a range of other bail conditions that are imposed. IDRS, in our experience, has found that very often people with cognitive disability are rearrested because they have not understood their bail conditions, and this can often lead to further charges. The third option is that the individual is charged and bail refused. Bail refused means that the person will be held in police custody until they are able to appear before a magistrate who will then make a bail determination. In this circumstance, they will also then be issued a court attendance notice to attend a particular court on a particular date. Because an individual is refused police bail, that does not mean that they will necessarily be refused bail when the matter comes before a magistrate. The purpose of bail is to ensure that an accused person goes to court and for the protection of the community. Bail is not supposed to be and is not intended to be in and of itself a punishment. Some bail concerns that are taken into consideration when making a bail determination. Will the person attend court when they are required to? What's the likelihood of them committing serious offences if they are given bail? What are the chances that they might endanger any person or any other members of the community? And what are the chances that they might interfere with witnesses or evidence related to the particular charges? I'll read another brief scenario based on IDRS experiences, which demonstrates that police sometimes believe that they only need to call a support person if they are going to interview a client. But as we have noted, and as I'd like to reiterate, CRIME, the Police Procedural Operating Manual, says that police should have a support person specifically for cautioning, interview, access to custody records and charging processes. The client, Joe, was arrested for offensive behaviour that was observed by several police witnesses. The police decided there was no need for them to interview Joe and that they would just give him a court attendance notice, so they didn't call for a support person. This meant that Joe had nobody to explain his bail conditions to him clearly and nobody to explain the importance of going to court on the allotted day, and he did not know that he needed to make an appointment to see legal aid beforehand. When someone is given bail, it means that they're allowed to leave police custody after being charged with an offence. It is always a requirement of bail that you attend court on your next court date, and as we've already noted, other bail conditions may be imposed too, depending on what the alleged offence is and what that person's offending history is. When you get bail, you have to sign a form acknowledging your bail and its conditions before you will be released. I'm now going to briefly outline the different levels of court in New South Wales. There are This flow chart shows the process for a person with a local court matter when they choose to plead either guilty or not guilty. The first time at court is usually a mention. Unless the person has decided to plead guilty and is ready to go ahead, the matter will usually be adjourned on the first day. There are many possible reasons for seeking an adjournment. The person is not ready to enter a plea or has decided to plead not guilty and defend the matter. In this instance, the solicitor then will need more time to collate information and evidence before advising the client about how to plead, or the solicitor for a person with a cognitive disability might be considering making a Section 32 application or asking for some other form of diversion. In these instances, an adjournment will often be required to collect additional reports and to do background research. A Section 32 application can be raised at any time during proceedings. It does not have to be at the mention or at the beginning of the process. It's really important to note that even though it is likely there will be an adjournment on the first court date, it is essential that a defendant is present at court. It is also essential that it is explained to clients with a cognitive disability that regardless of the seriousness of the alleged offence, they are likely to have to attend court on more than one occasion. If there's a reason to think that the person has a mental illness, the magistrate may ask the mental health liaison officer at the court to assess the person and make a recommendation to the magistrate. The defendant's solicitor may ask for this to happen. Sometimes people with cognitive disability may be referred to the mental health liaison officer at the court. The usual way through the court process, as demonstrated on this slide, is referred to as being dealt with at law. And that is, in that instance, the defendant will decide with their solicitor whether they will plead guilty or not guilty and defend the matter. Sometimes there may be an adjournment before an individual makes a plea. Sometimes, once the person has pleaded guilty, the magistrate may ask that a pre-sentence report be prepared by Community Corrections, which may be known to many people by its previous name of probation and parole. This report is to give the magistrate information to assist in deciding an appropriate penalty. The solicitor can suggest that a pre-sentence report should be provided. If the person has a disability, the magistrate may be more likely to agree. If a defendant pleads not guilty, there will usually be an adjournment to allow both the defendant's solicitor and the police to put together the evidence they want to put before the court. There might be several adjournments before everybody is ready to go ahead. A question that often arises is, what if a person with a cognitive disability doesn't turn up at court? As noted in the previous slide, it is essential to go to court regardless of what stage the matter is up to on a particular day. But three key things that could happen if a person does not turn up at court is that they could be arrested, they could be denied bail and kept in custody, and importantly, they could be found guilty even if they are not present at the court. In our experience, there are many reasons that a person with cognitive disability may not turn up at court. And it is also our experience that where someone has been connected with a support person through the Criminal Justice Support Network project at the Intellectual Disability Rights Service, that their chances of turning up at court are much, much, much higher. But some of the reasons that we've found that people may not turn up at court is that they may be confused and not remember the date. They may simply forget to go. They may be afraid to attend court. And if the offence was committed outside of their normal area of residence, they may not know how to get to the particular court, or they may get lost on the way there. It's important as support workers that we try to cover off these pitfalls and provide training and support prior to court to maximise the chances of our clients attending court on the dates that they are required to. Generally, everyone is told to be at court at 9:30 a.m, but it is impossible to know when your matter is going to be heard, so it's important that a person is prepared to be there all day. If there is an extremely good reason why someone can't attend court, for example, an accident or sickness, there's a central call centre number to call to advise a court that the person is unable to attend. They'll usually want a medical certificate to back this up. Even if a message is left with the call centre, it is still possible that 1. the matter may be finalised in the absence of the client, and 2. that a warrant may be issued for the person's arrest, and any bail may be forfeited. I'll now briefly outline the role of the Criminal Justice Support Network in providing court support. The Criminal Justice Support Network can provide trained support people to support individuals with cognitive disability at legal interviews, whether they're a victim, a witness or a defendant, in areas where we have trained Criminal Justice Support Network volunteers. This support can be provided over the phone if we do not have trained support people living in that area. A support person can also attend court with victims, witnesses or defendants with intellectual disability in a Criminal Justice Support Network area. Legal advice is also available for people with intellectual disability who have to go to court throughout New South Wales. If they can access our Sydney office, they are able to have this legal advice face-to-face. Otherwise, they are able to receive legal advice over the phone from anywhere in New South Wales. Please see the number on the bottom of the slide if you need to make a referral for this service. A person with intellectual disability or someone on their behalf can request legal advice from IDRS prior to court, or can request a CJSN support person to attend court with the person with cognitive disability. A support person may also be able to attend legal appointments prior to the court date. A question that often arises is, can IDRS solicitors represent a person with cognitive disability in criminal matters? IDRS solicitors do represent clients, but are not able to represent people in all situations. The cases IDRS would take on for representation are those where there is a reason why legal aid or the Aboriginal Legal Service cannot or will not represent the person. For example, the person is banned from receiving those services, or there is a conflict of interest, or where there is some particular challenge in representing the person that means that legal aid representation will not be adequate for the person. If there are particular problems with the legal representation, we encourage people to call IDRS for advice. As already mentioned, the court support volunteers from CJSN are trained by the Intellectual Disability Rights Service and are experienced in this role. At least 3 working days' notice is needed to arrange a court support person, especially in Sydney. So please refer your clients as soon as you know that a court support will be needed. I'm now going to briefly talk about some of the alternatives that are available in the local court for people with cognitive disability, with a particular focus on Section 32. But first, why have alternative outcomes for people with cognitive disability? The effect of disability may have had some influence on the alleged offence, It's very difficult for some people to comply with non-custodial penalties, for example community service, bond conditions and fines. People with cognitive disability are particularly vulnerable to assaults and other abuse in prison, and often have little or no access to programs which are going to assist them to address the offending behaviour. And it's been found that offending behaviour is more effectively reduced by programs and support in the community. The alleged offensive behaviour may be linked to an effect of the person's disability not understanding, meaning they do not understand appropriate behaviour. I'll give a case example to demonstrate this. Louis lived with his mother till she passed away when he was 42. He remained in the family home with assistance from his brother. He had had no activities outside his family and neighbourhood since leaving school. His brother taught him to get the bus to the local Westfield. While sitting at the bus stop, Louis sat close to a young girl on her way to primary school and started stroking her backpack, touching the girl in the process. She became upset when Louis didn't stop. A woman at the bus stop called the police, who took Louis to the police station and charged him with indecent assault before dropping him home. Louis's brother was surprised at what had happened until he found out that the backpack was decorated with pictures of butterflies. Louis's obsession. Louis went to court. He was given a Section 32 order with conditions that he receive education and relationship counselling, including appropriate social behaviour. This is a good example of why diversion can provide interventions which will support an individual to address the offending behaviour and reduce the chances of them reoffending. It is very difficult for some people to comply with some non-custodial penalties. For example, a person may not be able to organise themselves to attend community service or to adhere to the conditions of a bond. And as we've mentioned already, people with cognitive disability are particularly vulnerable to assaults and other abuse in prison, which can result in them spending time in solitary confinement. And there is often little or no access to treatment or programs that would reduce offending behaviour while the person is in prison. Programs and support options in the community are more likely to reduce offending behaviour and more likely to last into the future. In general, people with cognitive disability are usually charged with the less serious crimes. However, may find that they get custodial sentences due to repeat minor offending and the magistrate's frustration with this. I'll now briefly outline the elements of a Section 32. Section 32 of the Mental Health Forensic Procedures Act is the diversionary option for people with cognitive disability when a criminal charge is being heard in the local courts. Section 33, which some of you may be familiar with, is a similar diversionary option for people with mental illness. So what is a Section 32? A Section 32 allows a magistrate to divert matters from being dealt with in the usual way if a defendant has cognitive disability or mental illness. It is for local courts only and not for serious offences. The magistrate must decide whether it is more appropriate to deal with the matter via a therapeutic, rehabilitation approach rather than by punishment and sentencing. In each instance, it is up to the magistrate's discretion. A defendant's solicitor usually makes the Section 32 application to the court and must provide evidence to back it up of the link between that person's disability and their offending behaviour. It is not automatic. A Section 32 application can, though, be made at any time during the proceedings. It's important for successful 32 applications that they be a joint venture between the person with a cognitive disability, their solicitor, and the services involved in their lives. What are some of the features of a Section 32? There may be doubt about whether some people with cognitive disability are able to plead. For example, decide whether to plead guilty or not guilty. This includes understanding the options that they have, the pros and cons explained in their legal advice, and being able to advise the solicitor what they want the solicitor to do. Since the person doesn't have to enter a plea if applying for a Section 32, the availability of Section 32 means that the issue of the person's fitness to plead is not a major issue in local court matters. There are no procedures in the local court to deal with the situation where the defendant lacks capacity to plead. There is a long complex procedure in the higher courts if the defendant is unfit to plead. So some of the features of the Section 32, that the maximum length of a Section 32 order is 6 months. There is no limit on the number of times a Section 32 orders can be made, and this is at the magistrate's discretion. As just mentioned, a defendant does not have to plead guilty or not guilty, so therefore fitness to plead is not a major issue. So then, when can a magistrate make a Section 32 order? Under Section 32, a magistrate can deal with the matter via a Section 32 order if the defendant can show, on the balance of probabilities, that 1. He or she has a developmental disability, mental illness, or mental condition for which treatment is available in a mental health facility. Evidence of the person's disability must be produced for the court if the person applies for a Section 32 order. The most thorough evidence is a psychological or psychiatric report if the person has a mental illness. What to do if there is no report available? Sometimes legal aid will pay for a report, but this is getting harder. A service may need to help the solicitor with this. If you have any questions in relation to this, please contact the Intellectual Disability Rights Service directly. 2. If the matter is one where the magistrate believes that it is more appropriate to deal with the matter via a Section 32 rather than at law. 3. If there is a treatment or support plan. It's important to note that magistrates and other legal players are likely to be more familiar with the term treatment plan and may think in terms of psychiatrists and medication being a solution. This is because courts and solicitors are usually more familiar and knowledgeable about mental illness than cognitive disabilities. But the more appropriate term, where the plan relates to a person with a cognitive disability, is a support plan. This may need to be explained to the solicitor. It is usually wise to use both together to make sure everyone is clear. The lawyer will often need assistance from disability or community services to provide or advise about an appropriate support plan to support the Section 32 application. It's important for you to think about who in your service would be able to assist to put together a treatment or support plan for someone who was before the court. It is not always necessary for a treatment or support plan to be super professional if that is not possible. A well-explained plan to introduce 2 or 3 strategies, activities with explanations of why they are expected to assist to avoid future problems will often be adequate. It depends on the complexity of the person's needs, the complexity and seriousness of the charge, and how much convincing the solicitor thinks that the magistrate will need. What is a treatment or a support plan? Well, it describes why the proposed services, activities or treatment are expected to have a positive effect on reducing offending behaviour. It proposes activities, services, programs or treatment that will be provided to assist the person to stay out of trouble. It doesn't need to include everything the person is doing, but needs to focus on a few key strategies which are going to assist them to reduce the chances of them reoffending. And importantly, it needs to be doable and be aimed at preventing or reducing further offending behaviour. It needs to look at what is behind the behaviour that led to the offending. A treatment or support plan must be person-centred and worked out with the input and agreement of the person with cognitive disability to whatever extent is possible. It can propose services, programs, activities or treatment that can be provided to assist the person to stay out of trouble. And it should explain and describe why the proposed services, programs or treatment are expected to have a positive effect on reducing offending behaviour. And most importantly, they need to be appropriate and feasible for that particular individual at that particular point in time. It should be worked out with the person in collaboration, as they need to agree to and adhere to the plan. And as already stated, it shouldn't include everything the person is doing, but focus on a few key strategies which are going to assist that person to reduce their risk of reoffending. The orders that a magistrate can make with a Section 32. They can make an order that the charge be dismissed with conditions or without conditions. Conditions are usually to comply with all or some of the components of the support plan. It's preferable that the conditions are specific rather than very general, like things such as obeying all reasonable directions of. A condition like this is very unlikely to be meaningful or effective for a person with cognitive disability and is almost impossible to comply with. However, it is common to see such conditions on Section 32 orders. It is much better if orders reflect a genuine attempt to consider what might make a difference and focus on that. This sort of order contributes to the frustration with Section 32 orders for some people. If a person breaches the condition, they can be returned to a court and the matter can be dealt with at law if there is another charge. There is no court or justice sector oversight of Section 32 orders. If the person breaches the conditions of the order, the matter can be returned to court and may be reheard according to law, and if found guilty, a penalty can be imposed. This is at the discretion of the magistrate. Generally, it is a further charge that may bring the matter back to court. In theory, a breach of a Section 32 order can be reported to Community Corrections, who can refer the matter back to court. In the experience of IDRS, this is very rare. And finally, a magistrate may also require that a responsible person be nominated. The magistrate can name a responsible person in the order. If this is required, it is usually the service that is overseeing the services or care of the person. Requiring a responsible person is not common, but a service may need to agree to take this role, which involves notifying Community Corrections if there is a breach of the order. Generally, it would not be an individual named person in the role, but the occupant of a particular position in the organisation. That brings us to the end of this webinar. I'd like to thank you for your interest and for your attention, and I would encourage you to contact the Disability Justice Project or the Intellectual Disability Rights Service if you have any further questions. Thank you.